It is July 20th of 2026, and this is the Court Gallery. Today we have a packed docket where patience is wearing thin. First up, Judge Buckley handles a bizarre case where a man is accused of harassing his ex-girlfriend's sister over a dog named Tilly. Then we head to Judge McNally's courtroom where a defendant's constant procrastination and string of excuses might finally land her in jail. And finally, before Judge Stevens, a man who was already on probation for choking a woman is back in court for choking another woman, leaving the judge absolutely stunned. That's right, ladies and gentlemen. It's been one of those days. All that and more starts right now.
And it looks like we have 5 cases where both parties are present today out of our 13 cases that we have. See, we'll start with Deanna Harris and Willie Bailey. Each come on up, please. And while you're standing, if you'd each raise your hand, right hand. Swear the testimony in this case will be the truth, whole truth, and nothing but the truth.
Yes.
Be seated.
Why do you keep going in this?
Thank you. All right, Ms. Harris, Mr. Bailey is your sister's boyfriend, is that right?
I guess so, yes.
Okay. And you indicated that he assaulted you
Yes.
back in May?
Yep.
Okay. And then you said he's been sending you threatening texts?
Yes.
Tell me about that.
Well, I don't know if it's from him or the third party.
Who's the third party?
My Shakia Kelly.
Okay.
She's supposed to be my sister. Text messages.
What did they say?
Just pretty much kind of threatening me about my other case that me and Mr. Bailey have pending.
And what case is that?
Where I got a call from Mr. Bailey stating that someone needs to come and pick up my sister's kids because Shakia was going to hurt her kids. So I went over there as a concerned aunt to check on them because I am a mandated reporter, and those are my nieces and nephews. And while I was there, I was invited into the home, which is my sister's home. Mr. Bailey, it's not his home. So I entered the home and he automatically started yelling. He was drinking heavily. Well, I could smell the liquor on his breath. And we got to arguing back and forth, and he got in my face and assaulted me, and I defended myself.
Okay, this is what happened in May?
May 17th, no, May 20th.
Okay.
But I was arrested because he said that I broke in and assaulted him. And that's not what happened.
All right, and do you have a charge pending?
I do.
And what's the court date
Burglary and
what's the court date for that?
Well, I have pre-trial August 6th and then regular trial August 17th.
Okay, so you were charged criminally for being in the home, and then,
They said I broke in, which
right,
I didn't.
okay. And you're telling me that
I was
one,
invited
you
in.
were allowed there, and two, that while there, that Mr. Bailey assaulted you,
Mm-hmm.
and then I think you've said
Defending
in your,
myself.
then I think you've said in your petition subsequent to that, he's been sending you texts.
Yes. And I can send your sister back to jail, and you think you're going to send me to jail? Let's see. Bitch, I got so much shit on you. You're going to be losing everything and going to jail. We're going to see who's got the last laugh.
And so when were these sent?
These were, well, the dates aren't on here. It's just the time and the person that they were sent from. But
Okay,
in my phone, it has the dates on there.
yeah, what are the dates?
I have a date, John.
Well, it was a lot sent, but I have to go all the way back up to the top from the beginning. June 22nd of this year at 3:30 p.m.
Okay. All right. Have you had any other contact from Mr. Bailey subsequent to the incident in May? So after the incident in May, have you had any contact?
No,
with
because I
Mr.
have an
Bailey?
order protection, the state put on for me to Willie, so I stay away because I don't have time.
Okay, so as part of the burglary charge, there is a protection order where you're not to have contact with him.
Right,
Okay. So
with
you
him,
haven't seen or heard from him since that,
I haven't,
okay, other than the texts.
yes.
Okay. All right. Mr. Bailey, go ahead.
Yes, Your Honor. Public record. I don't appreciate you lining up on the oath and lining up to the
Okay, no, you're just talking to me.
Okay, yes, Your Honor. I don't appreciate her lying to you, Your Honor. Your Honor, number one, I never offered her to come into my house. I had surgery. I was laying down in the bed, number one. I thought it was her mother, and I opened up the door. She bust open the door. She just started attacking me with the scratches on my face, gashes, which you can have the pictures to show on record from the police and the ambulance that came. When she came in my house, assaulted me. My kids had to be outside naked because of her actions and her temper and the way she did. She violated the contact order, which I can show you through the proof through the mail, where she's trying to cover herself. She called, threatened her and threatened me. So was she trying to cover herself up to make herself look good in front of you, Honor, and line up on the oath? Number three, you sitting up there, you constantly doing things that you know that what you've been doing. So I'm not in to come up here and deal with your negligence and your lies. And I'm not gonna let you lie
All
to
right,
us.
no, you're talking to me.
Yes, Your Honor. And on top of it, yes, the charges will stay pending because of the simple fact, I'm not gonna deal with no liar and I'm not gonna deal with nobody that think they can do whatever they know to anybody. And for the fact, she called my phone and text this number right here, to which I have the proof, which she couldn't even give you the correct date and the time. I have the correct date and the time when she called in with the text message, which she can't even give you the correct time of the time that what she did and trying to cover herself, which she violated the contact order and tried to put a charge up on her that said I violated it or threatened her, but was she the one threatening me? And she's the one sending all the contacts to the phone, that which I don't know who she's trying to get the help or lie, but I have the proof in the documents. Your Honor.
So did you send the text that
No, she
Ms. Harris just read?
texted the phones. She texted this phone right here with all the information in it, with the time, the date, even the call. She didn't even post to call me. She called me when she got out of jail, calling her, trying to talk to her. She shouldn't even call the phone.
Okay, yep. So hold on a second. So that's the text.
This is the text message, and this message is for, I'm in a group chat with my mom and all my siblings. He has no part of, and when he talking about, I called when I got out of jail, I called my sister because my other sister said that Shaquille wanted to get all the information,
Okay,
wanted to get my side of the story. So I called my sister, but I had to let her know I can't, Willie can't be in the background, he can't be there. So I'm calling you because we're sisters and me and you don't have the order of protection. So I was doing right by the courts, going by that. Because she told me to call her when I got out of jail. I went directly to the hospital. I was in a bus accident. What I look like assaulted somebody 3 days later. And I have the proof. Sure do.
Okay. Well, we're not going to decide the assault case. That's apparently in Superior Court, and that will be resolved by them. So the text that you read to me.
Mm-hmm.
So what date do you have text?
The same day. I got it from all the beginning.
June 20. Okay.
I
Okay.
have all,
Hold
not
on.
the half cuts. Your Honor.
Me too.
Okay. Yeah. Hold on. Okay. So you're saying you did not, may I see your phone?
Yeah. This group chat is for my mother and her 7 children.
And
He is not a part of it.
Okay.
this don't got nothing to do with no group.
Okay. Yeah. No, I don't want the two of you going back and forth.
Your Honor, am
Okay.
I able to?
Yeah,
speak to say
Yeah.
something?
Hold on just a minute.
That's what my sister sent to the group chat.
Right. But what you read, you told me you were reading some
Yeah, it
texts that
was-
were from Mr. Bailey.
From that phone. He doesn't know my number, but my sister does. It's coming from her phone, from him.
And where is that in here? Actually, may I see what you read, what the copy is?
That's what you said.
Okay, hold on there.
What's your name, by it? As you can see there, she's here to taunt me.
Okay,
She don't have nothing to do with this case.
Horses.
okay, hold on. So Shiki is your sister?
That's my mom's daughter, yep.
Okay. Oh, when she sends you a text, it says she can send your sister back to jail. Who's she sending that text to?
I have another sister, Yuri.
Okay,
I don't know if she's telling Yuri I could send your sister back to jail or her and Yuri's situation, but that doesn't have anything to do with me. And she kept stating in the text messages, you two bitches are gonna regret it. For what? We didn't do anything to you.
okay.
Your baby daddy was the one that said that I assaulted him, so why are the sisters getting into it for somebody that don't have anything to do? I don't have anything to do with what went on with their situation.
So those two. Thank you. Okay,
Not even his phone, so how could I threaten him?
all right,
Not even
okay,
his
no, I
group
don't want
chat.
people talking to each other.
No, I was talking to you.
No, I know you were. And what are you showing me, Mr.
I'm
Bailey?
showing
What,
you how it all started from the beginning.
well, no, I'm not gonna read all the
Okay,
text,
I know.
just tell me what the purpose of this one is.
This is the purpose, saying that from the beginning, how that she tried to cut everything out from the beginning, how it all started. So basically, that's inaccurate with the half of what you.
Oh, and I know you're talking to me.
Yes, sir. It was
Okay, so-
inaccurate.
All right, so let me ask you a question.
Yes, sir.
Subsequent to what happened in May,
Yes, sir.
Have you in any way contacted Ms.
No,
Harris?
no, Your Honor. She been contacting me.
Okay, but
Your Honor.
have you in any way reached out to Ms. Harris?
No, Your Honor.
Okay, all right, thank you. Nancy. All right, so in this case, Ms. Harris has sought a protection order directing Mr. Bailey not to contact her. Mr. Bailey says he hasn't contacted her subsequent to an event that occurred back in May. Ms. Harris has a trial coming up on a burglary charge in that event in Superior Court. So as to what happened in May, we're going to let that matter be resolved in Superior Court. So that court will take whatever actions appropriate in that case. I was mostly concerned with what's happened since that date. Ms. Harris maintains that Mr. Bailey's been reaching out to her. I'm not satisfied that that's what's happened. I do see that somebody's been reaching out. It sounds more like your sister rather than Mr. Bailey. So I'm going to deny the order at this point and not enter it. What I will say is that Ms. Harris's request, in fact, she's gone to all this effort to be here and file this petition. So Mr. Bailey, she's made very clear she does not want you contacting. So make sure.
I don't
Just,
contact her at all.
yeah,
I don't know
I'm
far
letting
from
you,
Your
you've
Honor.
told me that. I'm just reminding you, she's made very clear that she doesn't want you contacting her. So to the extent that you do, she's free to come back in here and say, well, he's contacted me after we had that long conversation in court, so I need a protection.
Yes, Your Honor.
So I'm not going to grant it today, but it could happen in the future. So you can both just have seats back there and we'll get you copies of this order.
Thank you, Your Honor.
Thank you. All right, Brianna Lanier, Justin Larson, Mr. Faldudo, and Ms. Eshelman. All right, if all four of you would raise your right hands for me, please. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes, Your Honor.
I do.
Yes, Your Honor.
Okay, thank you. All right, folks, so I've read everything that's been filed by all of you in these cases, all your affidavits and the statements of other people. And frankly, after reading all of that, sounds like, I won't say that. I'll say this. I can't tell who's more at fault than others. You both seem to be aggravating each other to a high degree. So what I'm going to do is I'm going to enter protection orders both ways. I'm going to direct each family not to have contact with the other family and under the exact same terms. So I'm not going to, based on what I've read, there's no ability for me to pick and choose and decide who I think is a little bit more aggravating than the other. I just don't see that in this paperwork. So I'm going to make it very clear that neither family is supposed to have contact with the other. And I'll go over the exact terms once I get the order filled out. But I just wanted to let you know, I spent a lot of time on the stuff on the material that had been submitted in these cases. So I don't know that I need to hear anything different.
We appreciate that, Your Honor.
Your Honor, can I ask how you reached that decision?
Yes, by reading everything that's been filed.
Okay, would we have the opportunity to see what was filed?
Yeah, you've had the opportunity. You can always look into the file with district court, and it's all there for you to look at. But I've read all the statements. Okay, Mr. Faldudo, I'm not going through it. I've told you, I've read all the statements, both of parties, and it was clear from what you filed that it appeared to me that you had read what you had been given in the plaintiff's filings. So
I have only seen the evidence that was submitted online through the court system, Your Honor. I've never seen.
That's what I'm talking. That's exactly what I'm talking about. I've read everything that's been submitted to the court, and there's, pardon me, nothing else beyond what you can see. That's what I'm referring.
All I've seen is the photographs.
Mr.
Oh, I'm
Faldudo,
just,
stop.
yes,
I'm not arguing with you.
but not mine either, sir. I'm just trying to understand. Thank you.
Yep. All I'm referring to is what's in the file of this case and stuff that you have access to.
Okay.
Same
Thank
thing
you.
that you've read, I've read. And I've read your filings and their filings. All right. All right, so I'll make a very general record of my review of the documents that each party had filed regarding this case. Ms. Lanier and Mr. Larison had, and both parties indicated the same thing as to the relationship, which is their neighbors. And Ms. Lanier and Mr. Larison indicated that Mr. Faldudo revs his motorcycle as a means of, outside of their house, as a means of harassing them, that he's driven through their driveway, that he...
For God's sakes.
Okay, Mr. Faldudo, I'm not asking for a response. I'm letting you know what I've read. That's
Yes,
all
sir.
I'm telling. That Mr. Faldudo's made threats against Ms. Lanier and Mr. Larison. He's displayed a weapon at one point, and they believe he swerved at Mr. Larison. I assume with his motorcycle, was unclear. And Mr. Faldudo, on the other hand, indicates that Ms. Lanier, Mr. Larison, I think he was speaking mostly about Mr. Larison, has been intoxicated, and he threatens Mr. Faldudo and Ms. Eshelman that he's used the N-word towards them, which is entirely inappropriate and should never enter any conversation ever, period. Yeah, I'm just saying, if I ever see that again, that will persuade me to go a different way. So or hear about that. So I want to be very clear about that. That's totally inappropriate. And that Mr. Larison has made threats towards Ms. Eshelman and Mr. Faldudo. And I read the accompanying documents, and based on those, I will find in each case, it's appropriate for me to enter protection orders directing each party not to have contact with the other, not to do harm to the other. None of the parties named may go onto the property of the other. These orders will be in effect for 1 year from today's date. Hopefully that time will allow the parties to understand that they need to treat each other respectfully and with courtesy. And even if you don't have to like each other, I can't make you do that, but you should respect each other and respect each other's presence and your boundaries. And any violation would potentially be a violation that could be charged with a crime. So we're going to leave it there. These orders are in effect for 1 year from today's date. If any party needs it renewed, you can come back to court and ask for it to be renewed. And Ms. Lanier and Mr. Larison are present in court. We'll provide them copies of the orders, and we'll send copies to Mr. Faldudo and Ms. Eshelman. And I will indicate that the orders are entered under the exact same terms. There's no difference. There was a slight difference in the temporary order that had a 10-foot restriction. That's gone. It just says neither party may go on to the other party's property, period. And you're not to have any contact with them. So I don't want to hear about flipping somebody off. I don't want to hear about any sort of means of attempt contact to aggravate somebody. That would be a violation of the order.
Understood, Your Honor. Thank you.
Okay, we'll present each of you copies of, you can have seats back there as soon as these are ready. And for Mr. Faldudo and Ms. Eshelman, copies will be available in your file regarding these cases to the civil office at district court.
Thank you, Your Honor.
All right, thank you all. Ms. Donica Smith, Court Ventris, and Caleb Walkman. All right, I want all three of you to raise your right hands for me, please. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes, Your Honor.
Yes, Your Honor.
Okay, thank you. And Mr. Ventris, what were you doing sitting at the table when I came in?
Oh, I
Why'd you
thought they were
presume
present.
you were going to be called?
Well, this is my first time, so I was a bit
Okay.
confused.
All right, we'll start with Ms. Smith's case. Ms. Smith, you indicated that you and Mr. Vantris used to date, is that correct?
Yes, Your Honor.
And when did that end?
I believe it was May or June.
Okay. And you indicated in your petition that Mr. Vantris sexually assaulted you,
Yes, Your Honor.
that he strangled you,
Yes, Your Honor.
and that he bit you.
Yes, Your Honor.
And was all this in the same incident?
Yes.
And when was that?
I believe it was like in June before
Okay.
we broke up. It was probably June 6th.
Okay, is that what led to the breakup?
Yes.
And did you report any of that to law enforcement?
Yes, Your Honor.
And what happened there, do you know?
There is currently a police investigation and charges pending.
Okay. And you know that because you've spoken to the prosecutor's office or to the investigating law enforcement agency?
Yes.
Yes,
We're,
which?
we're supposed to be waiting for a call today from the sergeant who's investigating it.
Okay, so you haven't heard from the prosecutor's office yet?
Not yet, no.
Okay, I was curious about that. All right, and Mr. Walkman, what's your relationship to Mr. Vantris?
Acquaintance,
Okay, and your relationship to Ms. Smith?
friend,
Okay. All right, and as to and Ms. Smith, since this happened in early June, the events that you indicated and that you subsequently broke up with Mr. Vantris, have you heard from Mr. Vantris since that date?
No.
Okay. So what led you to, looks like maybe 3 weeks or 4 weeks later is when you filed the protection order. Why the delay in doing that?
He's been showing up to my neighborhood.
Okay, so he hasn't contacted you directly, but you've seen him in your neighborhood?
Yes, Your Honor.
Your Honor, law is
Okay,
false.
yeah, hold on. I'm gonna get to Mr. Vantris. And what neighborhood is that, Ms. Smith?
In Mund Lake.
Okay. And Mr. Vantris, to your knowledge, lives in Shelton?
Yes, Your Honor.
Okay. I'm asking Ms. Smith.
Yes.
And to your knowledge, Ms. Smith, Mr. Vantris had no other reason to be in the Mund Lake area, with the exception of knowing you there. Is that accurate?
Yes.
Okay. All right. And Mr. Walkman, you indicated in your petition that Mr. Vantris has threatened to kill you. Is that accurate?
yes,
Okay. And one time, multiple times, how did he communicate that?
it was one time it was to Danica.
Okay, and
It was
relayed
during
to
a
you.
time, yes, it was during a time where we all were hanging out at one point. I did not feel comfortable with him after hearing everything that he has done to Danica, and that is why I filed. He has also been showing up near my house, and there has been witnesses that have seen him also in her neighborhood as well.
Okay, and do you live at Mund Lake? Do you live someplace
No,
else?
I live next to Black Lake.
Okay, and you've seen Mr. Vantris in your neighborhood, or somebody's reported to you that they've seen him?
I've seen him in my neighborhood, and also other people have also seen him in my neighborhood and hers as well.
And this is subsequent to the events in early June?
Yes.
And when was the last time you had any communication at all with Mr. Vantris, if any?
The last time we hung out over at Deschutes River Park, that was right before they broke up.
Okay. And subsequent to that, have you told Mr. Vantris you don't want to hear from him? You don't want to see him? Have you said anything like that to him?
I have blocked him on everything, so there is no way for him to contact me.
Okay. Other than being in the neighborhood, and you haven't yelled to him, get out of my neighborhood or anything like that?
No, I have not.
Okay. And Ms. Smith, what did Mr. Vantris say regarding Mr. Walkman?
He was talking about like if I had gotten on the back of his bike that he would do something like hurt him or worse.
Oh, if you'd gotten on to Mr. Walkman's bike, that Mr. Vantris would hurt Mr. Walkman, is that what he told
Yes.
you? And when did he tell you that?
It was when we were hanging out at the it was Tumwater Falls. It was
Okay,
early
this-
June.
Okay, was this prior to the events that you indicated happened or after that?
After that.
Okay, Mr. Vantris, I'll give you a shot, but what I'm going to tell you is this, is that I understand from the information being provided that there is an ongoing criminal investigation. I don't have any more information other than what I've heard.
Mhm.
The allegations that I'm hearing, which I know to be at this point only allegations,
Mhm.
they're very serious,
Mhm.
very serious. If you're been placed under oath, if you say anything today and they go forward on charges,
Mhm.
Law enforcement will have access to anything you say today, and prosecutors could use that against you in
Mhm.
any potential trial that may occur in this case. If you had an attorney here today, I'm quite confident, based on what I've heard so far, that the attorney would say, do not say anything at all.
Mhm.
That's what an attorney would tell you today. So, do you have any questions about that?
No, sir.
Do you want to say anything today?
Those are all false. I did not threaten Mr. Watchman at all.
Okay, so remember, all these are potential crimes. Even your denials can be used against you. So be very careful about what you say if you want to say anything. Do you want to say anything more?
No, sir.
And Ms. Smith, you and Mr. Vantris never resided together, is that correct?
Yes.
I have a question. So she has this file as harassment, and she's saying I sexually assaulted her. So I know those probably won't be the same things, correct?
I'm sorry?
Harassment and sexual assault are two different things, correct?
Depends on how you're looking at them. Yeah, they can be. There's a harassment charge and there's an assault charge that are different in the criminal law. But sexually assaulting somebody is also considered harassment in the
Okay.
terms of protection.
I see.
Right, based on the testimony received, and we'll note that Mr. Vantris made the choice not to testify as to the substance of the allegations in this case. At my letting him know that there was potential prejudice to him if he did so by the use of any statements he made if there is to be a criminal trial in this case. So based on the evidence received from Ms. Smith and Mr. Walkman, I will enter the protection orders requested in this case. So Mr. Vantris, you're to have no contact with Ms. Smith or Mr. Walkman at all. You're not to go within 1,000 feet of Ms. Smith's residence or her person, and same for Mr. Walkman with also 1,000 feet of his workplace. And you're not to engage in any stalking behavior of Ms. Smith For Ms. Smith and Mr. Walkman, these orders will be in effect for 1 year from today's date. If you want them renewed, you'll have to come back to court and ask for them to be renewed. And Mr. Vantris is present in court. As you know, he's going to be provided with written copies of these orders. And if either one of you want copies of the orders, you can go to your file in district court and receive copies there. All right, thank you.
Thank you.
You can
Thank
just
you.
stay where you are, Mr. Vantris, and we'll make these copies and get them to you. Nicholas Scott. Last one.
Yes, Your Honor.
Mr. Scott, good morning.
Good morning.
Okay. Looks like just this morning we received proof of service.
Yeah, PD ended up being the one. So I had served him and submitted it Friday, but he actually showed up at my apartment complex, and I went ahead and had OPD then serve him again and have them submit as well.
And I don't see Mr. Little being present.
No, Your Honor. Can I ask a question, Your Honor?
Sure.
So in the initial petition, because part of his biggest problem with me is the fact that I've got my sister's dog, she's incarcerated at the moment, so I'm taking care of her dog. And in the initial petition, I did put under the pet section, I put her under there because I do walk around my complex with her and I take her everywhere with me. And he has tried to take her from me before. Is it possible? Because I noticed in the one that I was given that they approved, is she wasn't added in there, and I was just hoping that I could add her in there.
Okay. What's the dog's name?
Tilly.
L-O-Y or L-I-E?
Tillie.
Okay. That's how she spells it?
Yes. That's how the registration is put, at least. That's what she responds to, at least.
We're waiting for your file to come into court, so that's why
Thank
I'm
you.
stalling here.
No worries. I apologize. Yeah, he's contacted the police a couple times, and OPD is aware of the situation, and and Animal Services is actually aware as well of the situation and everything. So he's tried to use her for breeding purposes, and so
So he comes to where you live, he's threatened you, he wants to take Tilly from you. Are all those facts accurate?
Yes. He'll sit outside my door and he'll whisper to her to rile her up. He camps outside my apartment. He's camped outside the gate and yelled for me. He was caught about a week ago standing outside the Rocket down the road from my house, walking up and down, screaming my name and threatening to do unspeakable things to me because I'm transgender. So, yeah.
All waiting. Mr. Grover, you want to activate your audio and video, please? And Mr. Scott, just stay where you are. As soon as we get your paperwork, I'll move back to your case.
Yes, sir.
I do have a proof of service in the file for Mr. Little indicating that a Ms. Johnson served Mr. Little on the 16th of July at 10:30.
Yeah, and then OPD served him again a few nights ago.
All right. And he doesn't live in your same apartment complex, correct?
No, sir. He's actually homeless, and recently he's been staying at church that is just behind the a hotel that's directly in front of my complex, so that he can be over here first thing in the morning and standing outside our locked gate and things and trying to get in the gate. That's why I had asked in the initial one for him to not, since I walked Tilly around my complex, I had asked for a little bit of an extension on that to be pushed out so that I could still walk her around the complex and things, and it'd be okay, because I know he would go at exactly 1,000 feet and wait if he needed to, but he's been hiding in bushes and things around, and so I know the officer said carry the order if I got it today, because if he does try to jump out and grab her or attack me, to call them immediately.
And does that 1,000 foot barrier restrict his ability to find housing at the church?
No, it does not. The church is just a place that they sleep every now and then, but he's able to go stay. He's been offered housing elsewhere at Unity Commons shelter and on the other side of town. And so he's only staying over there because it's close to me and it was to harass me. So he's been told recently he can't be there if he's going to continue his behaviors. So, and that was by the church, actually.
And what's Mr. Little's connection to Tilly?
So my sister, whose dog it is, it's her ex-boyfriend. They had been together for about 6 months before she was incarcerated. And when she was incarcerated, she gave me custody of Tilly because I was housed and I could take care of her financially and things. And Anthony was angry about that because at the time he had gotten Tilly pregnant and he wanted the puppies so he could sell them and make money. And I, obviously, and I told him I didn't want the puppies, but they ended up getting taken by animal services because I couldn't take care of them in my studio apartment. I couldn't keep them. And so when they got weaned, I surrendered them to them, and he was upset about it. And he's been trying to get her. He and a couple people managed to kidnap her at one point and got her pregnant. And she ended up prematurely having the puppies and almost dying. And she was brought back to me, thankfully, about 4 weeks, I guess 3-4 weeks ago now. And I've been rehabilitating her back from almost death. And I'm working on getting her fixed right now, and OPD is helping me with that and things. But yeah, he's been trying to take her, especially since he found out that I'm getting her fixed. And so he's really upset. And yeah.
All right, so I have added conditions to this that are in addition to the conditions you had on the temporary order, which indicate that you were entitled to custody of Tilly and that Mr. Little can't come within 1,000 feet of Tilly.
Thank you so much.
Now, that addition means that Mr. Little now has to be served with a copy of this order. If I didn't add that, then his mere fact of not showing up in court wouldn't require him being reserved, but he does need to be reserved since I've changed the terms of that order. So you're going to have to work with OPD to get Mr. Little served again with a copy of the protection order.
Yes, Your Honor.
Okay. So I've noted that you'll work with OPD to get him served.
Yes, sir.
And this order will be in effect for 1 year from today's date. If you want it renewed, you'll have to come back to court and ask for it to be renewed.
Yes, sir. Thank you, Your Honor.
All righty. Thank you, Mr. Scott. And you should reach out to the civil office to get a copy of a service packet to get that to OPD.
Yes, Your Honor. Thank you.
You're welcome.
Bye-bye.
Donahue, come on up.
Yes.
Sorry you had to be the last one.
No apologies needed,
Somebody always has to be the last one. You just got that lucky card today.
as long as I'm seen and heard.
All right. So we're in the exact same case, situation here that the last couple of cases have been. Mr. Kovas has not been served.
I know.
Okay. And do you want to continue the case to try to get him served or drop it altogether? It's your choice.
Well, we had an incident last night. I took Betty, and I would like to add Betty to my,
There is no order at this point. You just have a
Right.
notice for a hearing.
sorry, my dog.
Yeah.
Having said that,
So you're
because
asking,
I heard him, okay, I'm not gonna digress. Anyway, we had an incident last night that, I went here, I went to this parking lot and I went to the benches. Lovely little area, had some food and a book and a cup of coffee. And Betty, I chained her up to the bench and we were about 4:35. I started reading my book and watching and listening to the music. And one by one, starting at around, well, almost immediately an hour after being there, about 2 cars came by and parked, which was unusual. Didn't mind it, didn't pay any attention, just kept reading. And then as the evening went on and the music got louder and it was nicer, a bunch of cars piled in. And then about an hour after that, if that, they started harassing me, saying this was a conversation that this one person had. He was in a white van. I have his license plate at home. It's not with me. He started saying that he had me on telephone being located for being human trafficked. And that's what this is all about. I do not have a phone. Leonard made it very possible to remove those phones from me in the last week or so. So it couldn't have been me, which I have proof of. And the cameras have proof of all the incidents that happened. I never left my bench unless to walk my dog. I stayed on that side where the picnic benches were, not where they were. And it got aggressively fast towards me and attacking me, and saying to me in so many words, "We're here because the locator said that you're giving out free sex." At no time in my life have I was raised Irish Catholic. Leonard knows that. And Leonard is abusing the system.
Was he there?
No, I don't. You know what? I take that back. I don't know. At this point, I had pulled out my mace. And it has been told to me many times. That's why I asked for this hearing last time. I have police cases. I've done my due diligence. I have a case with me, of evidence, license plate numbers, people saying it's Leonard Tobias. Okay, I'm gonna breathe. So the reason I did this the first time with Judge, I forget her name.
Wilcox.
He had come to the parking lot of Planet Fitness, which is on camera, in the parking lot, intimidating me, threatening me, keeping his distance from me, and mocking this whole situation that I've been told he has people who are protecting him.
So let me get you.
But it happened last night.
Okay, so let me just get you focused on what we need
Okay,
to
thank you.
Sure. We can't have a hearing unless Mr. Kovas has notice of the hearing. At this point, he doesn't have any formal notice of the hearing. So let me look.
All these things that I just asked for, I asked for a temporary so I can stay safe, so I can be back for the next one. I pleaded with the judge.
Right. Yeah, I'm not going to
And-
revisit Judge Wilcox's decision. Right now, we're going to just talk about,
I had to pull out mace last night.
okay, right now, we're just going to talk about getting Mr. Kovas served, but
I just got his address and I'm gonna be calling the police department down there.
okay, we don't have an address. We just have that
I
he
do.
lives in
just found
Florida.
I found it in Sarasota.
Okay.
My
Okay,
next
well,
question
okay,
about that.
yeah. Okay, Ms. Kovas, pardon me, Ms. Donahue, let me walk you through this. Yeah, do you believe Mr. Kovas, if he resides in Florida, how is he contacted?
He was just here. I just said July 7th, July 3rd.
So you
yes.
think he was here in person
Absolutely.
from Florida?
Absolutely.
Okay, so where do you think he's staying? Where would the police go to
I
serve
don't
him?
know what a criminal does, except
Okay.
when it's done to me.
Right. So there's not much we can do if you don't know where he is, because he needs to be handed a copy.
I'll hand him it if I have to.
No, you can't.
Then I will have the police. So then I looked up his information, and he has sexual assault
Okay,
charges in Florida.
okay. But right now, all we're talking about is being able to have a hearing. You don't, there's just you and I, there's no other person.
Is there a video going? And that was another thing I'll ask about later. So.
Okay, so the only thing we could talk about today is getting him served. And right now you don't know where he is.
Yes, I do. I have an address.
No, at where he is in the state of Washington to be served.
He can be served anywhere in this.
And you know how to go about getting him served?
Absolutely.
in
I've been doing
Sarasota?
all this work myself. I'm sure of it. I know a lot more and I'm just not.
Okay, I'm willing to reset this hearing 2 weeks to August 3rd. We can't keep resetting, but I'll reset it one time to August 3rd to see if you can get them served.
Then what about the incident last night? I'm telling you, you're not going to do anything. And it's on video. So I'm documenting that wait, let me just say, I'm documenting that there is video of me being almost physically attacked at Thurston County Judge parking lot yesterday. And I'm saying it's Leonard Cavallas with all the trails of evidence that I have and have presented to the police and to you. And you're saying nothing is going to be done but a reset.
I can't do anything different. Law enforcement can investigate it. You can say, hey, you should look to see if there are security cameras at the courthouse that maybe captured what happened last night. But that's up to law enforcement to check those.
And then are you here to protect me?
I'm here to discuss whether you're going to get a hearing on an order. That's my job.
But that's
Law
not what I
enforcement-
heard for 2 hours.
Okay, Ms. Donahue, it's law enforcement's job to enforce any orders that the court issues. We can't issue any orders until we have a hearing. So we need Mr. Kovas present. And that's the only issue I can talk about today is he's not present because he hasn't been given a copy of the notice of the hearing. So
I have a question.
you can, if he's engaged in crimes, it doesn't take a protection order to have law enforcement act. They just need proof of a crime. So if you believe a crime has occurred, as in last night, then you contact law enforcement and say, this is what happened. And here's what I believe. I believe there might be security camera video that shows
No, there
that.
is.
So,
I looked it up already before I came here this
Okay.
morning.
well, you talk to law enforcement about that. That's how you get last night addressed. So would you like me to set this to the 3rd of August?
I do, but I just have one more question
Sure.
because I was here for 2 hours and I heard you even protecting a dog better than what you're doing for me.
Okay, that's not the point.
Yes, it is. Yes,
Okay. So you want to have a hearing on the 3rd of August?
I do.
Okay, and we can't do anything on the 3rd of August unless Mr. Kovas has
Absolutely.
been served.
Sure.
And we'll be in the same
But it
courtroom.
doesn't matter. This is a question about this. So one person just didn't show up and you just said, oh, happy go lucky, we'll just reset it for you. But now you're saying this is the one and only reset I get, depending on.
One, and it's same thing for everybody who gets a reset.
Okay.
It's one reset.
And then one more question, and this is where I should go. I can't, there's people that are looking for the video from my last hearing and can't find it. Where would we go and look for that? Because it says when you look up the thing and you,
Yeah, the videos just last 24 hours. So if you want a transcript of it, you can make a formal request to the court, submit something in writing saying you would like a copy of the hearing from the 7th of July, and you'll get a copy of that.
and then where would the court be? You right now? I request it.
You go out to the front window. in
Front
the lobby.
window. Okay. And then I have 24 hours here with this one?
Yeah, they're typically left up about 24 hours. Just depends when the clerk gets to
And
deleting
so
it.
before I leave here,
Mhm.
it is, the paper I got for the 20th. Is that correct? For
Yeah,
this hearing right now?
today's the 20th. Now we're setting it to August 3rd to give you a chance to get
Correct.
Mr. Kovas.
You are correct on that.
And you would like to arrange to get him served.
Absolutely.
Okay, and you'll take care of that whether he's here or in Florida or wherever he is. I'll tell you this, if you believe he's in Florida, the
He comes
advice
up here all the time.
what's that?
He comes up here all the time.
Okay, okay. If you listen to me for a second, then you'll understand why I'm telling you this. If you have an actual address for him in Florida and you believe you can get him served in Florida because you have an actual address for him, you can serve him in Florida, but you're much more likely to get success if you file your request for protection order in his county in Florida, because they will enforce a Florida service and order. So if you want to refile this in wherever he lives in Florida and get their law enforcement to serve him, you can do that. You can try it here, but we'll see if a sheriff in wherever Florida, if you convince them to serve him, great. But a Washington resident trying to convince the Florida sheriff to serve one of their residents, maybe not happen.
This one, I read his charges,
Okay, all right.
and
I'm just
they're
letting
very
you know.
similar to what I'm asking.
Okay, we'll see you on the 3rd of August, and what you're going to need to do is just sit out in the lobby out there, and somebody will bring you a copy of the
No, I
service
go, I know the drill. Thank you, though.
service packet.
Yeah.
Okay.
And then my question is what if, because you weren't able or legally allowed to serve me a temporary, which is minor, being that he's from Florida, you would think that I would get that. What happens if something physically does happen? Because it almost happened last night.
Okay. So what I told you before is you don't need a protection order if somebody.
I understand, but where does the court stand in being responsible?
Okay, well, the court wouldn't be responsible if somebody does something like that. I'm not revisiting Judge Wilcox's
Okay,
issue.
thank you very much for your time.
Okay, thank you.
Anaya. Go against Jessica Lynn Anaya, 25R 514-118A, 24R 254-240.
Good morning, Judge and staff. John Graziani, appearing on behalf of Jessica Lyons in my lap. Please identify yourself. Jessica Lyons.
All right, I took these pleas under 771. She pled, so let me just back it up here. I'm gonna need Madeline, and you can call over there with hers.
Judge, she's still technically in violation, and I did speak with Madeline. I'm happy to have her come over because she'll confirm the fact that although it's been slow progress, Ms. Anaya has been making progress. She's not becoming the service, should have been done by this time. She's also gotten rid of the warrant out of Lincoln Park, which is on a drunk driving case.
So it had a disorderly that was reduced to 771.1 on 25R 254-240. She was in here on May the 21. She pled guilty to failure to pay her fines and costs as ordered, failure to attend her scheduled visit on May 11, and failed to clear all warrants by May 1. Then on the other file, 25R 514-118A, she was in here on a furnishing alcohol to minor, which I also took under 771.1, and she pled guilty to failure to complete 20 hours of community service. So on that date, back on June the 22nd, I said I'd set a sentencing date today at 8:30. And her community service hours she was supposed to have done was 20 hours. I first gave her until June the 1st of 26. So where are we with everything here? What is she doing?
Judge, what's happened is she has completed, well, go ahead, Ms. Raptis.
Your name?
Madam Rogers, probation.
I can't wait to hear. Tell me what's
Judge,
going
what's
on.
been happening is she has completed 24.5
I'll
hours.
provide proof of that to you.
She did.
Are you satisfied with that?
She still has 20.5 hours left to complete, that have been long overdue. But she has made some progress.
Judge, under the circumstances, I believe she's made significant progress. She's gotten rid of the warrant of Lincoln Park. Secondly, she's next going to be getting rid of the warrant out of 36th District Court. She is working.
She's got, hang on.
It's long overdue, Judge, but she is making progress.
You're
She got
very
some-
immature. You know that, Ms. Anaya? Very immature. How old are you?
I'm 36.
It's time to grow up.
I'm trying to get it out the way.
You're trying to what?
Get everything out the way. It's taking me a little longer than expected.
Why? Tell me why. Get a little.
Don't drive.
Why don't you drive? You don't have a license?
No, I,
Do you ever have a license?
yes,
You got it suspended or revoked?
yes,
Which?
suspended.
Why?
It was a drunk driving out of Lincoln Park at 2020, Judge, and she failed to address it. She owes another $500. She'll be dealing with that with Judge Clifton. She has another issue out of 36th District Court, but it is less than $120. She is making progress, Judge. She got a paycheck recently.
Remind me, do you have kids?
Yes,
Sure. Yes,
Are
there.
you married?
No.
Any of the fathers in their lives?
One.
Is it this?
Judge, it's a difficult situation, and although it doesn't look as good as it should, she has been working very hard. She has the support of her mother. I would hope that this.
Here's the problem. I cannot keep going on a 771 case longer than a year. I sentenced her May 15th of 25. Now it looks like did I revoke that status? It looks like, Heather, and yeah, I did. And I sentenced her on the other case, on that case, March 19, to serve 20 more hours by June 1. And that's all I ordered. Then on the other case, on the Rockwood case, did I ever revoke that status?
I don't believe you.
And which one? They're both Rockwood cases, Judge. So that one would be that one ending in, is that the 240 or the 118?
Correct.
The 240?
Yeah.
Let me look at the,
Well, I only placed her on probation on that on March 19th.
I don't see anything revoked that I'm seeing on that one.
Can I ask you a question? Why, when I told you on May 21 to clear all your warrants, first you had until when I took the plea on May 21, after you failed to clear by May the 1, why didn't you go clear those warrants yet?
It's just been a transportation issue.
No.
A money issue. I don't have transportation to get to Detroit at 8 o'clock in the morning.
Well,
I could get there to the Lincoln Park one. And the other warrants is just for $294 traffic tickets, which I can't see online.
can you run that? My lien here is dated June the 15th. Will you make sure that warrant's cleared out of Lincoln Park?
Judge, I did verify that she just cleared that warrant on the 16th last week.
16th of July.
Yes, at Lincoln Park. The Detroit warrants are still active. I looked those up. I was able to see them through Vinewood.
Why do you procrastinate? How did you get to work? How did you get to Lincoln Park?
A friend of mine.
Why couldn't you have gotten a friend of yours to take you over there long before July 16th?
It was hard to get her to take me then.
Judges, there's no excuse, and please take into consideration keep her out of jail with the fact that she's made progress, albeit too slow, but nonetheless, she is making progress, that she does take this matter seriously.
Anything? Defense declare all warrants by sentencing date, I wrote down. I don't know why, I just feel like you
Judge.
need
progress-
to proceed in life. How do I say this? With more promptness. Let me just put it that way. We don't get to procrastinate. Heather, give me a date in 3 weeks. I'm gonna adjourn this one last time. I'm gonna have this done, you're going to jail, okay? You're gonna clear your warrants, you're gonna take care of everything, you're gonna have your community service done. Again, if you don't, you're going to jail. Adjourn 3 more weeks, last chance, ma'am.
3
Feel
weeks,
okay.
I'm sorry, Judge, 3 weeks you're not here, we could go to the 17th.
During August 17th at what time?
We could do 8:45.
Judge, if, I don't think she'll be unsuccessful, I think she'll be successful, but if she is not
Tell
successful,
her to bring her toothbrush and underwear
how much time in jail, Judge?
the whole time.
Okay,
Okay?
thank you, sir.
August 17th at 8:45. You better get it done. And I'm writing down. Or jail if not completed. And you know what I'm gonna do? Just so I don't miss it myself, which I won't, I'm gonna make sure I highlight this. Gotta grow up. Just gotta grow up. Go down the hall, get your notices. We'll see you back here. Thank you.
Thank you, Judge.
Thanks. People against Cantu, this is Francisco Elijah's Cantu, 25F 244-762A.
Good morning, Judge. Detailed Williams on behalf of Francisco Cantu, who's standing to my left. Today is the date set for show cause.
Good morning, Mr. Williams. And your name, sir?
Francisco Cantu.
I placed your client on probation on January the 29th of 26 and ordered him not to consume alcohol. And I have a charge here that alleges that he would fail to refrain from consuming alcohol or drugs testing positive for alcohol. And then it says he was subsequently arrested for OWI as well as resisting obstructing officer. So how was he going to proceed on this?
Judge, if it may, as a matter of housekeeping, my client is going to plead guilty to violating your probation. However, and we certainly can do that, but I'd like to bring you up to speed as to what happened up in Standish, Michigan. I actually represented him in Standish. And then,
I mean, I don't have a problem. I'm just telling you, you get a drunk driving, you go on probation. And you
understood.
go out and get another drunk driving, you got a big problem. You know what I'm saying?
Yes, Judge, we're fully aware of that. And that's why Mr. Cantu was able to retain my services to come here. And I'm hoping that after I explain the circumstances and what the judge did up north, with you in mind and probation down here in mind, we might be able to move forward.
So, sir, do you wish to plead guilty to this charge or fail to refrain from consuming? So that case has already been disposed of.
It is, Judge.
So I'm gonna count this as two different violations. One, failure to refrain from consuming. I could have them amend the show cause if you want.
Judge, it's not necessary.
So otherwise, I will simply state that with your permission, that count one would be failure to refrain from consuming alcohol, which is a technical violation. Count two is that he was convicted of operating while intoxicated. Was he convicted of operating while
He
intoxicated?
was, Judge.
Was he also convicted of resisting obstructing officer?
Misdemeanor resisting, obstructing a police officer.
So really I've got three counts here then.
Correct.
And so I have your permission to treat them as three counts.
You do, Your Honor.
Sir, if you plead guilty to failure to refrain from consuming alcohol on March the 27th, can you call Jessica in here, please? That would be deemed a technical violation. You get 5 days on that. If you plead guilty to violating a law, operating while intoxicated, and resist and obstruct, those are two different offenses. Those would be a conviction for violation of law. Those would be deemed to be non-technical violations. You could get 93 days on those charges. Do you understand that?
Yes.
Did he sign an advice of rights form today?
He did. Where is he?
The yellow advice of rights, there we go.
Can I approach?
You sure can. You can hand it right to safety.
I'll do that.
If
You
you,
can fill that out, and we're obviously familiar with those advice and rights.
if you plead guilty to this, sir, I want you to understand that your probation on those two charges could be revoked. Do you understand that? As a result of those two convictions, you could get 93 days. Do you understand that?
Yes.
And again, did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
Your name?
Just vote.
He's agreed. We're treating them as three different counts. Count one, failure to refrain from consuming alcohol. Count two, being convicted of OWI. Count three, being convicted of R&M. So, to the charge that you failed to refrain from consuming alcohol, testing positive on a PVT on March 27 to 26, how do you plead to that?
Guilty.
Did you consume alcohol on that date?
Yes.
And did you have a PVT on that date as part of a drunk driving arrest that registered .165?
Yes.
Was the count two that you were convicted of operating while intoxicated arising out of that offense date of March the 27th of 26? How do you plead to that? Were you convicted of operating while intoxicated arising out of that offense?
Yes.
As to the charge that you were convicted of of resisting obstructing officer arising out of that offense date on March the 27th, how do you plead?
Guilty.
And were you convicted of that charge?
Yes.
Anybody force you to plead guilty? All right, I'm gonna accept your plea. So again, taking your pleas to all three counts, one technical, two non-technical, which again, on a first technical, you can only get 5 days. On the crimes, you understand you could get 93 days with credit for any time served on this case, correct? Just let me make a note here, and then I want to listen intently to you.
Big Judge.
All right, Mr. Williams, go ahead and tell me what you'd like to say.
So number one, Judge, thank you to your staff, especially Mr. O'Donnell, for allowing us to meet with the show cause. I kept in touch with the court because at one point in time, I hadn't been retained in this case yet. I told him that, you eventually need to hire an attorney. And I'm glad that he was able to hire me because I represented him up in Standish. So Judge, he gets put on probation later. Doesn't get out to a good start. Then obviously this particular situation happened. Judge, it was a high VAC, it was resisting.
What was his blood
Alcohol level was a 2.6. Judge, he was almost, now, the good news about this judge is, and I've seen all the squad car videos, that Mr. Cantu had the wherewithal to pull over. And at some time he pulled over, his car was in the park, it wasn't in a Taco Bell parking lot. And then obviously.
It wasn't a Taco.
It was not, Judge, it wasn't in a drive-through, so in other words, it was not per se operating the vehicle, but he obviously got there. The trooper came upon him, he was dead asleep, and the resisting came from when he was waking up and obviously being intoxicated.
Where was he pulled over?
It was in Standish. Judge.
I know, but whereabouts?
Judge, I wanna say.
Side of the road?
Yeah, it was on the side of the road.
Expressway?
Yeah, it was near I-75. Okay, it was I-75 near M1190, which is the Standish exit. So, but it was in park, he was asleep, he pulled over and parked his car. So that is what I want to make clear it wasn't an accident, so on and so forth. He was belligerent and it raised to resisting, but after the prosecutor and I looked at the squad car video, that's when he agreed to reduce it to an attempt. So as we're going through the PCC and the preliminary exam, he got a court date here at one point in time.
Why was he charged with a felony because of the assault, resistant, obstruct?
Correct. Yes, Judge. It's a 2-year.
Right.
Right.
So there was no other reason other than that he was charged with a felony because he only had the one prior.
Correct, Judge. As a matter of fact, they reduced the OWI to an impaired, but impaired second, but it really doesn't matter. It was, so he pled guilty to the impaired and the attempt RNL, which is a 1-year misdemeanor. Actually both 1-year misdemeanors. So in the midst of that, we were actually, when he got one of the court notices, we were actually up in Standish. And that's when I called the court and realized that he missed a date down here. And then I think they reset it to June, and he was in the Aranac County Jail. So as I discussed this matter with the judge, he wanted to know what was going on down here, what would happen. And I said, well, I know Judge McNally well, and hopefully I have the opportunity to represent Francisco on this case. And so what the judge did, was he wanted to hear from my client. And it was one of those, I'm gonna put this guy in jail for 9 months. That's what he had in his notes that he showed me. And he goes, and I want to hear from Mr. Cantu. And Mr. Cantu didn't play games with the judge, was forthright with the judge, and he ended up getting 25 days in jail on both cases. He has an immobilization of his vehicle that's mandatory. We're working that out because he's going to turn his car in its lease. And then he has a online offender correction.
How long did the judge give him to immobilize the vehicle?
Actually, he needs to resolve it this week. So, because again, what he's doing, he's turning his car in on a lease. His mother's here, drove him today. Obviously, his license has been revoked because it's 2 within 7, so he's not driving. Throughout all this, he's managed to maintain his employment with Hydraulic, which is an automotive wiring company in Roseville. He's still residing in Warren with your father, correct?
I'm by myself.
Okay, you're by yourself, but he's still managing to at least keep his job. So what the judge said to me was, if he lived up here, he has some contacts up there, I want to put him on probation. You know, that's what I wanted to. And so they had a dialogue and they had an understanding. And he said, what I would like to see is, you know, he said, and that's up to you, Mr. Williams. And I told the judge, I want to represent him and go back in front of Judge McNally. He lives here. He's in this area. He's not going to have a
He
drug.
lives in Warren though.
Well, yeah, I understand that, Judge. So I'm not talking about, what I'm saying is, if you put him in jail, he's already done 25 days. I suppose I could have made a motion to try to get something to run concurrent, but he didn't have the resources to do that. My idea, Judge, is that he's done his 25 days, and now we've got a very young man that has 2 drunk drivings. We avoided the felon. And my idea is, I don't think we should give up. I think
Did the police report one of you?
Judge.
How
I
bel-
highlighted the specific section that I'd like you to take a look at as well.
Must have gotten pretty belligerent.
That was section I
The
highlighted.
judge is saying 9 months.
Judge, it was, we don't need to repeat it on the record,
I
but
won't.
the vernacular it was egregious.
God, I hate that. God, I hate that.
I know, and
I don't care how many drinks you had. I don't care how many drugs you had. You ought to be ashamed of yourself talking to somebody like that. I just hate that. I don't know why anybody thinks that they're better than somebody else because of the color of their skin or religious preference or sexual orientation or anything else. I could care less. Makes me sick.
Judge, and
Wow.
it does,
And then you're talking to a police officer like this. Well, can you come here, please? Is your father in your life? I mean, are your parents still married? Has your father been in your life?
Yeah.
Go ahead.
Judge, and I know what people wanted to say out loud was that, and I'm gonna say it, the fact that police officer was not African American.
Was not.
Was not. And I believe if he was, I
just don't.
I don't think there would have been, I don't think he would have been given the consideration, but here he is speaking to you and Judge Fuldridge did the same thing that you're doing right now, just looking at him and gave him the opportunity to say, well, why am I not doing this? My client was able to extend an apology to the trooper. And, and it's a small.
Where did he do his 25 days then?
He did it in there county.
All 25 days.
How many did you do? Did you do all 25? He had credit for one judge and that was a good time, so he did, I want to say it was 20 or 22 days.
Judge, if I could add, I looked up his case today. It's still listed as open, so I assume he was sentenced to probation on this as well. I don't know if he's aware. He's scheduled for a show cause hearing for tomorrow on July 21st.
That is because of the immobilization issue. That's it, because that's going to be mobilization. And we're obviously working on it. He still has the online, course. He has the offender correction program, and as I said before, Judge, it's the immobilization issue. I'm in contact with the probation department. He's hopefully getting the car turned in today. If not, he's got to go up there and show.
Do you have the order of sentence from the Standish judge?
With my notes on it, Judge.
Oh, I mean,
Sure.
I'll take it your word.
Yeah.
So he did place him in probation anyway, am I understanding correctly?
What he did was, he placed him on probation to complete these particular terms.
That would work, hang on.
Thank you.
And then obviously the judge said, I'm not going to.
So he did serve,
Right, I'm sorry, Judge.
We're not on record.
oh, I'm sorry. Okay, so we're back on record. We had a little problem. He's not on probation. It says probation none.
Yeah, that's why I wasn't sure based on when I looked it up on iMikeWorks. All I saw that it was still open and it was scheduled for a show cause. So that's.
He just ordered him to complete an offender corrections course within 60 days. Did he do that yet?
No, he's not done that yet.
Why not?
Well, that's money, honestly, because it's an online, he's got to pay for it online. He's keeping everything, he's trying to keep his job, obviously tried to retain me to come before you. It's on his to-do list, he still has time to do it. And then obviously the immediate thing is the immobilization. And he's gonna have to be down there, he's gonna have to be there tomorrow. Ironically, the lender's up there. He just couldn't go turn the car into the dealership. The lender had to pick it up, and they've been playing games with him that they're gonna bring a tow truck driver to get it. So he may just have to bring his car up directly to the lender tomorrow because he has the show cause. I'm hoping we can resolve it today, but nonetheless, and then the online is $150. He'll be able to do that. He's just clearing one hurdle after another. And judges, you can see the way they bifurcated that is 20 days on the drunk driving or the OWI, and it's 25.
He passed all his tests all the time on us?
We were doing twice monthly testing. He showed up for testing. Testing was always negative with us. They didn't have any issues with testing.
Did his court work? He did his community service? He did this?
He did not, for us, he only did his two court work program days and his victims impact panel. He did not do his 8 hours of community service. I never received any proof of that. And then he did not complete the substance of abuse class B order.
Maybe that's the problem. We can't beg people to do this. What was the date of the offense on this case again? I'm talking about the one out of Arlington,
April, Judge?
March 28th.
Yeah, March 28th.
You know, maybe if you'd have gotten in the treatment program between January 28th, 29th and March the 28th, maybe this wouldn't have happened.
And if I may, Judge, therein lies what I'm thinking from, and what the judge, what the Judge Wolbeck in Marion was thinking. He says, obviously I can't put him on probation up here, but and I can give him 6 months, and then he doesn't know you, but I know you. And so Mr. Cantu has been punished up there. He hasn't been punished down here. I get that. And maybe he should to some extent. That's up for you to decide. But 25 days in jail. Let's say you did 45 here, you did 25 here, and you cut him loose. That's not gonna solve anything. And so he doesn't have a driver's license. He still has a job. We have a sober link available. He's got a million resources up in Warren to get the outpatient, probably talking about an IOP now. That's something to consider. To punt and do whatever is, maybe he has learned his lesson, maybe he's done whatever, but all I know is that we have an individual on 25 years of age, with 2 drunk drivings and a high VAC. And I'd like to see him, do the work, whether that includes jail from this court and then continue probation. That's the way I'm seeing it, Judge.
Any thoughts?
Again, I think Mr. Cantu is young. I think these are 2 back-to-back drunk drivings with 25 years old. I think that we need to realize that there are consequences for them. You can't play games. This was cases and warrants for a while before he finally got some representation to come clear this up. Again, I think the police report too, I don't like how he spoke to the officer and the resisting, things like that, that whether you're drunk or not, that's no way to speak to somebody. Again, I think there just needs to be some serious consequences. I don't think probation should be answered. Especially considering the fact we still have a show cause scheduled on the other. It's the case he did jail time. I understand it's regarding mobilization, but as of right now, it's not their time with that.
Yeah, ruin your life before Slurs. You know that? All you gotta do is get one more of these between now and 2090, and you're gonna have a felony. I mean, I'm torn. I'm not gonna mind telling you. I mean, I've got a kid here that complied with our probation for the most part, but didn't do some of the most important aspects like the treatment. Didn't do his community service. Passed the test. But then he goes out and drinks. Not only does he drink, he gets obliterated. Not only does he drink and get obliterated, he blows over 3 times the legal limit. I don't have enough time to get you through sobriety court. If you live closer here or even in Warren, I could get you through sobriety court, but now it's too late. You're 6 months into your probationary term. I don't like the way you talk to this officer. I think that's something you're gonna have to look in the mirror and chastise yourself about. And if you're not willing to do that, then there's something wrong with you. Really. I just don't go for the bigotry out there and talking like that. I don't understand why people think they're better than other people. I mean, I guess if you're emperor of the world, maybe you are, but you're not, and you'll never be. And none of us will ever be. I want you to take a copy of this. I want you to give the original back to Mr. Williams.
There's a front and back as well, Judge.
Yeah.
You didn't notice.
Times I get a little stumped, and I shouldn't be stumped at all, but I am, because I still think maybe, just maybe, you're still worth saving, but you gotta grow up. Mom, he's gotta grow up. I'm gonna assume you were never raised to talk to people like that.
Definitely not.
Well, then don't do it. Here's what I'm doing. Only because I don't want to make a knee-jerk reaction. I'm setting a sentencing date in 3 weeks. I'm setting a bond, a personal bond of $2,500. You're to be on a SoberLink device by the end of the day. You are to be in intensive outpatient treatment by the time you come back. You are to test weekly. And if I was you, I'd make sure I had my community service done. If any one of those things are not in order, you will get 93 days with credit for time served for me. I don't have to run these concurrent. They don't arise out of the same event, transaction, or occurrence, and I don't have to, and I won't. Do we understand one another?
Yes.
Give me a sentencing date in 3 weeks. Sober link device by the end of the day, Mr. Williams. If you want to have him, where's your office again?
I'm in Troy.
I don't mind if you want to zoom in and have him zoom in, or he can come to your office, better yet, one or the other. Give me a date, Heather, please.
Do you want to do that, August 17th date?
That's
The week after
perfect.
you're back? Okay. We could do, I'm sorry, 9 o'clock?
9 o'clock. Is that good, Mr. Williams?
It is. Thank you for asking. I personally. I can be here. And how much community service was it?
8 hours.
I personally think you're gonna be doing a lot of this for naught. Okay? Because I'm not likely to cut you a break. But I don't like to make knee-jerk reactions. Your lawyer's making a lot of sense here, even though you talk like filth. And I'm gonna think, because I want to make sure I'm right, at least to the best of my ability. I want you to take this report back. I want to see all these reports again. And I want to make sure that you give him a copy of this and this. I want the screening. Can you get those to me like 3 or 4 days with the memo before then? You're to stay in touch with your probation officer, and you are to let her know where you are with all of this. I would make sure you are 100% compliant. Mom, you better tell him how serious the judge is. If he can't read it by now, I don't know what to tell him. Good luck. We'll see you on that date. Thank you. People against.
Judge, do you have an objection to EMS tether? It's in Hazel Park, like a mile away from Warren.
We use house arrest, which is in Warren.
Okay.
You guys work that. Okay,
And then-
we always use house arrest.
And then community services, can you do it up where he lives?
You can do it
Does-
in Timbuktu if he wants.
But.
Be a nonprofit organization.
Fantastic.
Mackenzie Lynn Goff, 25B148638, A and C.
Good morning, Judge and staff. John Valesky, appearing on behalf of Mackenzie Goff, who's to my left.
Your name, ma'am? On July 30th, 25, I sentenced her under HIDA on the charge of contributing to the delinquency of a minor. I also sentenced her on that same date to the charge of larceny. And then on February the 11th, well, she didn't appear for review hearing date, show cause for review hearing date on January 14. I issued a show cause for failure to appear for the review date. And then she didn't show up January 28th. I show caused her again. She didn't show up February the 11th. Finally, I entered the conviction. Why wasn't she here?
Judge, it appears that there's been a mix-up and her mother could help explain. She's right in the back. What happened is, she had been working, she had moved from, Huron Township to, Trenton, and, there may have been a mix-up. She did everything that was asked of her, and, I'd spoken with Miss Wilds, and, she confirmed that. Is that correct, Miss Wilds?
She completed her work program, community service, she had paid her money, Judge, in full.
Well, it says here balance zero back on December 17 of 25.
One of her files had a balance of 0. They now both have a balance because of bond fees. So I talked to counsel, her A case, I think it's A case has a $30 balance. There was a $300 bond posted on that. I believe that is bond costs on that. The C case is the one that carried the balance.
How much does she owe on the C case?
Currently, I believe, again, I believe it's 130. Judge, I'd have to double check. I looked at it.
That's correct.
So she owes 130 on the C case. And she's paid the balance on the A case up except for the warrant fees, right?
That's what it appears to be, yes.
Yeah, just the bond cost is on the A case.
Sorry?
I'm just showing that the bond cost is the only thing on her A case from her bond that she posted. We have the 10% on there.
Why didn't she show up, counsel?
Judge, it appeared that there was an honest mix-up. She was working at Sheets. She was gainfully employed.
At where?
At Sheets gas station in the Huron Township area. I believe there's one at Romulus. Am I correct? Were you working at the Romulus one? And then it was an honest mix-up because there's no reason for her to do that. She comes from a good family and she wanted to get this situated. It appears that you under the conviction. I was hopeful that she would be in a position where she could still have that.
Who posted the money here? Who's Chase Ramsey?
That's her boyfriend. So
You were supposed to notify us if a change of address.
say yes or no.
I did not let you guys know. I know I should have.
Yeah, you should have. You think we got better things to do than, nothing better to do than continually ordering show causes? Where's Chase at?
He's working.
All right, I want to make sure I got this straight because how immature are you? Can I ask you that?
Answer the question.
Well, you're 19. Come on, you got to grow up and act like it. I mean, I gave you every benefit. I must have show caused her 3 times or sent new dates. Whose fault is that? You think we're going to send out a private investigator to find you?
Set up a private investigator. Judge, she made a stupid mistake.
I know. But let me ask you a question. She at one time had a balance of 0 on the 638A case, right?
Yes, Judge.
And then on 638C, she still owes, I'm sorry, you told me 125 or 130?
130.
Why don't you call up your boyfriend? Is he working? Yes? Can you get a hold of him? Go tell him to allow you to apply unless you can pay it, 130 on the A file or on the C file. I'll waive any balances on the A file. And I'll just go ahead and dismiss the case if you haven't had any other new charges. Why don't you go call him, but I'm not gonna wait long.
Judge, when would you recall? About 10 to 15
5 minutes.
Okay, call him up right now.
Sure, and the halt to your right. Good luck to you. Thank you. Have a good day.
Hello, Judge.
Are you ready? Is Goff ready?
Goff is not ready. She's actually on the phone. Okay, the young man said yes.
Okay, have her tell him he's got to call that number I gave you, Heather, 6710201 extension 228.
Okay.
And bring
thank
her
you so much.
and bring her back in the courtroom.
Okay, thank you, sir.
Thanks. So Heather, I wanted to authorize 125 on the C file.
But she has the 130 on the C file, Judge. That's what the bond.
Are they coming? Goff and Graziani?
Let me see what's going on. And I got 2 more Brownstown matters.
Okay, thanks. Is he calling, ma'am? Who's Goff?
Yeah, he's coming up.
He's coming here?
Yeah, he has, yeah, to get his,
Where's he live? Where's he at?
he's driving out of Buda, I just called him, he's close.
Thank you for your understanding.
He's coming now?
Say yes or no.
Yes.
Mackenzie Lynn Goff, 25B 148638, A and C.
John Buckley, on behalf of Mackenzie Goff.
Raise your name,
Your name, please.
raise your right hand. You solemnly swear affirm the penalties of perjury, the testimony you'll give in these proceedings will hold yourself, you God.
Yes.
Since I sentenced you on July 30th, 25, on these two cases, have you been arrested?
I was arrested from
As a result of these underlying charges, that's what.
Since then. Since July 30th, have you been arrested on any new charges? Have you had any contact with the police? Do you have any other cases pending? All right, I'm gonna go ahead. Your boyfriend's coming up on file C. I want him to pay 130. I won't require any payment on file A. I'll set aside the convictions and I will dismiss the cases. But he's gotta come here. If he doesn't come here, that's conditioned on him paying the 130 on that file. Heather,
Good shot, your compassion.
okay?
Okay, Judge.
I don't know if I'm compassionate.
You've been good, Judge. Thank you.
Have a good day. Good luck, young lady. Grow up a little bit. You gotta grow up. Grow up. Grow up. You don't want this kind of nonsense on your record unless you wanna be lucky to salt the fries at McDonald's. You follow me? Good luck. Stay out of here. I don't want to see you again.
Thank you, Judge.
Thank you. Make sure he comes up here. Don't leave until he does.
Right. 20-34701 is called the State of Texas versus Michael Anthony Resendez. That's you?
Yes, sir.
With Mr. West?
There's none against you, Your Honor.
Your attorney and the state's attorney? Yeah.
Yeah, there's
a new
PRP and there's a new case. It's all
Okay.
part of it.
And then we've got a new case. What are we doing today?
8 years, both of them, CC. Revoke them on, revoke them based on this small offense, new offense, 8 years, and then get 2
Okay.
years on this.
34701 and 20. Okay, so the motion to revoke was earlier in time.
Right.
And there's a motion to revoke unadjudicated probation in this 34701, and you are Michael Anthony Resendez, and here with John West, your attorney. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation in this 34701? Can we proceed in summary?
Yes, Your Honor, please.
In summary, motion states that on June 10th, 2021, in this criminal court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation for assault, family violence by choking, a third-degree felony. Is all of that true? Yes. Okay. Fine. Nothing pleasing there. I have an indictment, a pending indictment, 26 CR 1151, that alleges the defendant committed assault on or about May 16th, 2026. Allegation 1 states he committed assault and family violence on or about May 15th, 2026. Is that the same thing? Is that the same event we're talking about?
It should have been May 16th, is what my sheet says they put at 16th. 15th is what it says on there, or?
It says 15 on the thing.
But
Yeah, it's on or about covers it, but that's the same.
It's on or about. I just want to make sure that's the same.
Yes, sir.
event
It
we're
is.
talking
Yeah.
about.
It's the same
Okay.
one, Jeff.
So he knows you're going to be the motion will be to revoke probation will be based upon the allegation of this new indictment so you get you by committing one bad act, it gets you in trouble in 2 cases. Do you understand?
Yes, sir.
And they're going to be running together
in
this. That's your plan. All right. So you, again, allegation 1 states you committed the offense of assault, family violence by strangulation. Oh boy, that's 2 in a row. We have here on or about May 15th, 2026 in Jefferson County, Texas, which is a violation of condition 1 of your probation order. Condition 1 of your order states you shall commit no offense against the laws of this state or any other state or of the United States. And assault is a violation of state law. Do you understand what you're charged with here in allegation 1 of this motion to revoke probation? Is this true and correct as it is alleged, sir?
Yes.
And are you pleading true and correct to this voluntarily and because it is true?
Yes.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked and
All my witnesses are served now.
you can be now found guilty of this third-degree felony of assault, family violence by choking, that you were placed on deferred or regular or unadjudicated probation for, and you could be sentenced up to 10 years in prison. Knowing that, do you insist on pleading true today? Yes?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. All right.
That's what was written.
Where to begin? This is this indictment, what you're pleading true to, what you were placed on probation true, has the same issue. You choked somebody. When you put your hands around somebody's neck and squeeze, there's only one intent. That's to seriously injure them or kill them. We put you on probation for this. And you're back violating probation for choking another person. What is it about that? I mean, you could kill, this could be potentially, you can just run up a number of people killed. This choking someone, you shut off they have to breathe. When you close your ability to breathe, you can die. You understand that? Yes?
Yes, sir.
Okay.
I'm sorry.
Why do you keep doing this? I mean, it's really not any less lethal than shooting them with a gun. When you strangle somebody, strangulation is what it is, which is very serious and inhumane. But that's to kill someone. These are loved ones, right? Yes?
Yes, sir.
Well, it begs the question, what would you do to someone you didn't know or like if you got angry with them? If you're going to strangle your loved ones. And it's another female. It's a different female, right? The motion is based upon, well, you were placed on probation for assault, family violence by choking a female, and now it's a different female you're choking that's causing your probation to be revoked, right?
Yes, sir.
And if they die, we call that murder. You're looking at the life in prison. All right. On back to 34701. Again, you're looking at up to 10 years in prison, and an agreement's been reached in your case where your probation would be revoked. You would be found guilty and sentenced to 8 years in prison to run concurrently with the new strangulation case. Do you understand? Is this your plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
I've never done, I can't even fathom putting my hands around somebody's neck and squeezing it. I've never done that in my life. I've never even thought about doing that. I think,
Don't remember doing it, sir.
sir,
Don't remember doing it. I was.
well, but you did it. You're admitting to it. Were you on drugs or something? No? Good luck on finding a woman to live your life with when this sort of thing gets around. Like half the population are females, you know. That's who you prefer strangulate. Strangle. But this is fixable. But you got to treat a lady with dignity and respect, right? This person, were you married to this person that you were on probation for?
We were engaged.
Sir?
We were engaged. We've been together 6 years now.
Yeah, you were engaged. I mean, it's about as close to marriage as you can get, but you pledged love and promises. And I'm sure this is a very good person. You lost them as a partner who wants to be around this. You know the difference between assaults and love. This isn't intimacy. This is not. Yeah. I've been married 40 years. My God, I can't even imagine.
Is there anybody else we need other?
My partner of life. I'm sure these are wonderful people. Well, God, you've got to fix this and treat the lady like they need to be treated with respect and love. Hurt them. Let me ask you, when you grew up in your household, was that something your dad did or anything?
My parents been separated for 23 years now.
Yeah, but I mean, did he commit assault on her?
My stepdad's used to beat my mom.
Sir?
My stepdad's used to beat my mom.
Was he a good person? No. Well, and your mother should never be mistreated by something, you know that. And so I don't want that pouring over to you as a lifestyle. That's not the right thing to do. And I'm sure knowing about it makes you upset that your mother would be victimized by someone, much less someone who said they love you. But don't be carrying on this bad habit in another generation. You make your own choices. You make your own choices. Fix this, sir. All right, I'll show you what's marked as State's Exhibit 1. John, help me here on this. Did you sign that? Understand it? Discuss it with your attorney? Is everything true and correct? State's Exhibit 1 is tendered into
No objection.
without objection admitted. This states if I follow this agreement, among other things, you have no right of appeal. I'm going to follow this agreement on this. If nothing further, I'm going to find that there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by a preponderance of the evidence or greater as allegation 1. That the defendant committed the offense of assault, family violence by strangulation on or about May 15th, 2026 in Jefferson County, Texas, which is a violation of condition 1 of this motion to revoke probation order, that he was placed on probation for, which states don't commit a crime. Thus, this motion is revoked, and your deferred or unadjudicated probation is hereby withdrawn and revoked. Earlier in this case, when we placed you on probation, you had pleaded guilty to the 3rd-degree felony of assault, family violence by choking voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt from that State's Exhibit 1 that you signed when we placed you on deferred or unadjudicated probation some 5 years ago. I now find you guilty beyond a reasonable doubt based upon your revocation, the revocation of probation in this case. And you were hereby found guilty of this assault, family violence by choking, 3rd-degree felony. And following this agreement, you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. You understand what's happened in this case?
Yes, sir.
We go then to the new indictment, 26 CR 1151. Well, it didn't fall into the trash can like they've not, like happened before, which is always a, I believe that's a message from up above when that goes into the trash.
They didn't need to dismissal.
All right, in this 26 CR 1151, the state of Texas versus Michael Anthony Resendez here with your attorney, Mr. West, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, Your Honor, please.
In summary, this new indictment states that on or about May 16th, 2026 in Jefferson County, Texas, you committed the third-degree felony of assault, family violence by choking a person you had a dating relationship with. Do you understand what you're charged with here, sir?
Yes.
And this is a third-degree felony like the other choking case that we dealt with on the motion to revoke probation earlier, which means you face a term if convicted of no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
Yes.
Yes, sir.
An agreement's been reached in your case here that you would be pleading guilty, sentenced to 8 years in prison to run concurrently with the previous case, 20-34701, the earlier choking family violence case that you were on probation for which your probation was revoked and you were sentenced to 8 years in prison just a few minutes ago. Is this the understanding of the plan in this case as well?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead guilty or not guilty for this case?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. You have to speak out so she can hear. Yes?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney. Is everything true and correct here?
Yes, sir.
State's Exhibit 1 tendered.
No objection.
Without objection admitted. This states as before, you are mentally competent to enter your guilty plea in this case voluntarily, knowingly, intelligently. You understand and appreciate the consequences of pleading guilty. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, please.
I'm going to follow this agreement. I will find that the defendant is mentally competent to enter his guilty plea. You are doing this freely and voluntarily. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea, to find you guilty beyond a reasonable doubt. In this case, I find you guilty beyond a reasonable doubt of this third-degree felony of assault, family violence by choking the neck of the complainant. You are hereby found guilty beyond a reasonable doubt of this third-degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. These sentences of 8 years imprisonment in each of these cases shall run concurrently. Do you understand what has happened today, sir?
Yes, sir.
And on each of these judgments, it will reflect that these are crimes of family violence. Anything else? That is all.
That's what my sure.
Do better.
Thanks, good. Everything's.
Do better. Words that we can all live by, ladies and gentlemen. Me most especially included. Do better. OSG, it's great to see you out there tonight. I'm sorry about the video starting to play there. I put my head. Look, these headphones, I can't keep them in the whole time we're here. So I have this playing on my speakers over here, and if I had the microphone on with the speakers on, there'd be that whole reverb thing, and it's not fun. So I put my headphones on at the very end of the show, making sure that I'm prepared, music can play, I can talk, I can say good night everybody, and thank you everybody for being you. But sometimes if I have a video playing in the background, like I don't know, Godslayer review video from some Elder Scrolls Online that I've been playing in my spare time, I don't know. You know, it's weird sounds can come out. That's this guy. That's what happens. Thank you all so very much for hanging out with me tonight. Most especially Unbiased Jurist, Rhonda and Darth Steven, X25, all of my super chatters. Unbiased Jurist said, thanks, Mama Wolfie, for being you. Thank you. Thank you, Unbiased Jurist, for being you. Thank all of you for just being you. That's something everybody. Rhonda says long time overdue payment. That's just not even fair. That's, you know, you owe. Hey, yeah, you're right. Never mind. Pops in for more M&Ms. Darth Steven says, you know, that M&Ms are good. ET phone home. Oh wait, that's the other one. That's the Reese's. It's the Reese's Pieces. No biting unless you can prove you're a wolf. And even if you can prove you're a wolf, maybe no biting. Maybe some playful nibbling. There's some growling, but not really any biting at all. Yeah. Natasha Kitty, thank you also. Marty Duvall, thank you for the jewels, the bops, the happy poops, and all that type of good stuff. Hutch, I see you out there also. I didn't say hello to you. I didn't say hello to most of you. I'm a horrible host in that way. Hey, you can depend that I'm trying to get better every single day as we do this. And every single day, same wolf time, same wolf channel, you can come back here and see if I got any better. It's not a good chance that anything will have changed, but you might be pleasantly surprised from time to time. I can guarantee every single night I will have some very interesting court cases compiled together. And if it's not a bunch of cases compiled together, then it's one big case spanned across the whole period of time, or multiple sessions even. This Saturday, we have a Judge Stevens, the John Dixon case. Don't bring a gun to a fist fight. It's got some pretty interesting video along with it also, some body cam video. I know my friends like their body cam video. But for now, let's say thank you again. Keep on being you. I am me, and I'm Lone Wolf Oosel. I'm your humble host. And for now, I am out. And remember, only you can take a bite out of crime. Bye!